Our plaintiff in the Lerner-Sampson case is a guy named Phil Turner. Phil Turner coaches baseball with Jim Douglas. Jim Douglas is a lawyer and baseball coach and swimming coach. But in his baseball capacity, they stood side by side all summer long, and Phil was embarrassed to tell him that they had moved out of their house because they had received a foreclosure complaint in the mail. And when somebody else, another parent on the team, said, hey, you ought to talk to Phil about his foreclosure, it was only until then that Phil was able to get help from Jim and we were able to get the foreclosure case dismissed, because the person that bringing the foreclosure action, of course, didn't hold the note that was suspecting Phil to his home. And Lerner-Sampson, in bringing this case, didn't do any due diligence to try to find out whether it was true. And this is not an isolated situation. Just look at the numbers in the Lerner-Sampson situation. In Ohio alone, Lerner-Sampson files 50,000 foreclosures a year. They have less than 50 lawyers on staff. And their lawyers spend the vast majority of their day in court or now in modification and mediation processes throughout the state of Ohio. The possibility that a lawyer took an objective, ethically responsible look at those mortgage foreclosure complaints that they were filed and verified that the people that were asking them to file them on their behalf actually own the note is just, it's a practical impossibility based on the number of hours in the day and the number of lawyers that they have working for. Those are the ones that we think, the people that were unrepresented in the process are the ones that we're trying our hardest to look out for as time goes on. Because I think one of the things we've accomplished for the more activist minority of people that are subject to foreclosure actions, one of the things I'm most proud of in my short time as Attorney General was working with the Supreme Court and the legal aid societies throughout the state of Ohio to create the Save the Dream program, to mobilize what at the time was the largest mobilization of the private bar for pro bono work. Those folks are okay because even a bad lawyer looking at these pleadings can frame and raise issues related to standing and the arguments. The first thing you do as a lawyer when you get a complaint is make sure the person that's suing you has the right to do so. A first-year lawyer can do it. And so we've mobilized very good lawyers who have been able to step up both to help people with that modification process and make sure they don't get run over in that process, but also to help look at these mortgages critically. But to date, tens of thousands, maybe over 100,000 people in Ohio have gone to foreclosure without that happening. And any foreclosure that began after 2006, I would consider, and I hope you consider as you look at doing your due diligence, to be suspect. And answering those questions and satisfying yourself about that, or seeking the appropriate indemnification from those people that ignored that process, I think is going to be a more and more important business objective for people involved in the title industry, and frankly, people involved in buying real estate, people involved in lending money to those who buy real estate. I think it's all wide open as to what the outcome will be. So with all that good news about what's going on in Ohio, and like everything else, my hope is that by using the legal process, by trying to enforce these settlement agreements, by trying to reform the way the foreclosures are conducted by these law firms in the state of Ohio, without regard to whether they actually represent people that have the right to foreclose, that we will make a difference and the process going forward will change. I think proof positive of that is that the Cuyahoga County courts now actually require, either the lawyer's got to sign an affidavit that no lawyer's malpractice insurer would let them sign, or they've got to come into the courtroom with the wet note showing that they own that note, having it in their possession, because under the Uniform Commercial Code, it's just like that. We were talking about it at lunch. If you went to the bank with a photocopy of a check, how many of you think the bank would cash that check? Under Ohio law, an unassigned endorsement on a promissory note is totally allowable. But if you don't, but what the courts in Ohio have been doing, particularly with people who are unrepresented, is allowing that to go forward to judgment without ever proving or knowing that that original check is in the hands of the person that produced the photocopy. If Ohio Savings, it's not good enough for Ohio Savings, it certainly shouldn't be good enough for the Cuyahoga County Common Pleas Court, or at the current time, it's still good enough for 87 other Common Pleas Courts in the state of Ohio. So until that process is reformed, we still have a lot of work to do. Questions? Paul?
Mark, this whole system where you have a servicer delegates the lawsuit to an intermediary party, LPS often. LPS then is effectively the client that hires the attorney. And there's no relationship whatsoever with the actual servicer. So, I mean, there's another layer of mis- and non-communication. Are you seeing that play out?
Not only we're seeing that, but we're seeing, and we haven't gotten the agreement that they're using in Ohio yet, but we're seeking it through our case. What we're seeing is LPS is getting a kickback from the law firms that it's hiring. So what Paul's referring to is there's a funneling process that goes on. Most of the servicers use a firm, and I think there's two of them, but the big one is lender processing services. When their loans go into default, they hire lender processing services to handle the mechanics of foreclosure. Lender processing services has a process for hiring outside law firms, which frankly is going to become very important, I think, in our lawsuit. And I'm not, look, I'm not embarrassed to say that. I'm not giving you any great strategy. I want to fix this problem. I don't want to put anybody out of business. Many of the lawyers that work for Lerner Sampson are fine people trying to do a good job. But the problem, there's so many inherent conflicts built into the process, including the fact that every time they refer a case, the LPS refers a case to Lerner Sampson or a firm like it, they immediately get $125 back from that law firm to buy the documents that LPS is hired to manufacture sometimes on behalf of the servicer or the servicer's clients, who are these distant trusts. At the end of the day, none of this is even in the interest of the bondholders. So the bondholders at one end are at risk, as are the homeowners at the other end of the transaction. And the more layers in between, the more potential for fraud. And not necessarily the kind of, I don't think somebody's sitting in the back room sharpening their knives and saying, we're going to really stick it to these people. But it's the inadvertent fraud that's going on that is causing people to leave homes that they have the right to live in, and causing people to be foreclosed on by people that don't hold their note, and subjecting them potentially in the future to being collected upon by somebody else who actually does. Because no question, we haven't represented a single person that didn't sign a promissory note in a foreclosure defense. Well, kind of. One that wasn't notarized doesn't count, Grace. But we have represented lots of people who were being sued by the person that didn't hold that note. Lots of people. I think just in our office it's in the hundreds now. Any questions?
Are you planning on going after any other large foreclosure firms, or just going to Lerner at this point?
Well, we got a very favorable ruling on our motion to dismiss, which says that if law firms are, and we can prove that they are, filing foreclosure cases when they knew or should have known that they didn't have clients that had standing, that's a violation of Ohio Consumer Sales Practices Act. Now think about the context of this. Lerner Sampson files 50,000 Ohio cases a year. The statute of limitations on a Consumer Sales Practices Act case is 2 years. So in the 2 years preceding the filing of our lawsuit, 100,000 cases were filed. Even if 10% of those mortgages were recklessly filed without representing the proper party, the civil penalties alone under the Consumer Sales Practices Act is $5,000 per case. So $50 million potential debt, and that's without getting to damages. That's without getting to framing some solutions going forward that make the rest of the state's foreclosure practices look more like what's now finally going on in Cuyahoga County. Or putting people who have potentially been foreclosed on by these folks inappropriately on notice of their legal rights. Or funding the representation of those that can't afford, even if they knew, it dawned on me, we were working at this ideas for how to ultimately resolve this matter, and we're nowhere near getting there. But I got a recall notice on my car. That might be a valuable service that could be done to put people on notice that they may be the victim of a robo-signed document, and leave it to the private bar at that point to step up and do what needs to be done. Because if there is indeed a Consumer Sales Practices Act claim, attorney's fees goes along with that as well. So suddenly we can find the beauty of the plaintiff's bar and leverage their muscle to bring justice to folks, and not necessarily just hold the law firm accountable, because there's lots of people up the stream that are also accountable as well. And we'll find that out as we go through discovery, and probably be adding more parties as well. So the answer is the three of us are chewing a very big elephant right now, and But if we finish this one, we certainly are going to be looking for others.
The discrepancy between the 8th District and the 9th District as to you have to own the note to bring the action in. Ashtabula County is the same way as Cuyahoga County is if you can't prove you own it when you file, then don't walk in the door. Where is that conflict now? Because has it made its way to the Ohio Supreme Court yet?
It has, only in the sense that Wells Fargo versus Jordan, which is the Cuyahoga County case, was submitted to the Ohio Supreme Court. It was appealed by Wells Fargo, and they declined to hear it. So there's some indication by their declination to hear the case that they're endorsing that decision. Now, I represented a guy in Delaware County who made a certiorari where Delaware County goes the way of Lorain County, and we appealed that to the Supreme Court, and they declined to hear that case too.
Right.
So the answer is, at some point they're going to probably have to tackle this, and let's hope that the Ohio Supreme Court is less political than it's sometimes been historically been as it relates to these types of issues. I mean, we'll see. I don't know what will happen. But the fact is that in certain appellate districts, and that's where, and actually this is, it goes to the heart of some of the defense that Lerner Sampson's trying to raise to the case, that this is an unsettled area of law. Well, in Cuyahoga County, it is not unsettled at all.
We had a federal court decision in December of 2007
Correct.
that clearly spelled this out.
And by the way, there was also a 2008 decision in the Southern District of Ohio. So all of Ohio was subject to at least one federal court decision saying that standing was required before filing. Now, they make an argument that federal jurisdictional case law is slightly different than state jurisdictional case law, but it's not a very good argument.
Wait a second, we're talking about real estate in the state of Ohio, aren't we?
Right, correct.
Okay.
Right.
Okay, wanted to make sure.
Right. But I think they thought they figured it out filing all these cases in federal court. You know, who in the world is going to go over there and defend something, right? And the truth is that nobody needed anybody to defend him. Boyko did it himself.
Right.
Yeah.
You know, he reached in and did his job. You know, which is, and to the credit of the Cuyahoga County Common Police Bench, they have stepped up and started to do that. Far beyond, I mean, Paul and I were in some of these initial meetings about this rule, far beyond what anybody ever expected they would do. Not that I didn't expect them to do the right thing, but they've really reestablished the rule of law and due process for people who were fortunate enough to not be foreclosed on before this year. For those going back, that's going to be left to the courts. That's going to be left to the cases like we're bringing with Davitt and Mickley to try to unwind. Well, thank you so much for the opportunity to be here. I hope I didn't bore you too much or too rusty. Not so good with this thing, but I really appreciate the chance to be here. And if Jim or Grace or I can ever help you sort one of these questions out, we're delighted to do so.